Hi, folks. Thanks for joining us today. In previous episodes of Is That Even Constitutional, we have talked about President Trump and cabinet level agencies and independent agencies, kind of what's the difference between them at a very high level. But today we're going to do a little bit of a deeper dive of the differences among the agencies and a little bit about why that matters. And so today, as always, while I'm not a constitutional scholar, my friend Ken is, and he'll be joining us to help walk us through that. Hi, Ken. How are you?
Hey, Sadhna. How are you?
I am doing all right. And so maybe just to get us started, you can kick us off with the different types of agencies that there are.
Sure. So what's interesting about this is that I feel like until very recently, the different types of agencies were of interest mostly to first-year law students, maybe second-year law students, and administrative lawyers, and that was about it. The two main agencies that I want to talk about are what we might refer to as executive agencies, and the second are independent agencies. Executive agencies include agencies that we would mostly hear about in the news, which would be things like Health and Human Services, Department of Justice, Department of State, kind of the big cabinet level agencies, and might include some other executive branch agencies, which are kind of the classic agencies, the agencies that spend money, litigate, manage grants, things that we think of as executing the laws that Congress passes. Then there is a much larger number of agencies that are considered independent agencies, and these are agencies that do things that are perhaps a little more regulatory or a little more adjudicatory, and we'll talk about that, but they are agencies that principally regulate or adjudicate regarding businesses. And so some examples of that would be things like the Security and Exchange Commission, which regulates the stock market, or the Federal Trade Commission, which regulates businesses. So these are entities that have generally different issues in the sense that one is more executing the laws, doing the business of government, and then the second, the independent agencies are more along the lines of regulating third parties and helping discern essentially how the law is going to apply to third parties, whether through regulations or through performing some adjudicatory functions.
Yeah, and so and if I'm kind of remembering this right, there's about like 15 of those executive agencies, right? Like so, agriculture, education, health and human services, housing and urban development. Like as you were describing, those are the ones that are probably like most familiar to folks. Education, defense. So I'm not naming all of them, but kind of giving a flavor of the types. And then there's so many more independent agencies. I want to say over 100.
Yes, that's exactly right. And there are big ones and there are little ones. Some of the little ones we've even been hearing about recently. So, for instance, the Assassination Archive Commission, which held the JFK assassination records, is one that we know about because President Donald Trump made an issue of saying that he wanted those records to be released, even some that had not been released for national security purposes until very recently. So some of these independent agencies are actually quite small, don't even have particularly large functions that are known to the general public. But on the other hand, the number of these independent agencies have fairly large economic regulatory purposes. But yes, there's at least 100. And if you included ceremonial agencies and very small agencies, it would probably reach several hundred. But the independent agencies that do the economic regulatory, something over about 100.
That's amazing. And so I think one of the prompts for this episode was that, it seems that Donald Trump and the current administration wants to kind of get rid of some of these agencies. And so could you talk a little bit more about, why that is and kind of is that even possible?
Right. So I think that we can distinguish between getting rid of independent agencies, and there certainly is the possibility of President Trump wanting to do that in the same way he might want to get rid of even executive branch agencies. But then there's also the idea of bringing independent agencies under the authority, the direct authority of the president. Now, why is this controversial? Well, the reason it's controversial is, as I alluded to before, these agencies have always engaged in what we might consider to be more quasi-judicial or quasi-legislative functions. Now, for this reason, the agencies have never been quite considered to be within the executive branch. So let's go back to the very first independent agency, which was the Interstate Trade Commission. The Interstate Trade Commission was created in the 1880s, and it was created because the Western railroads had a near monopoly over the rail lines going back and forth between the major markets and the mostly resource-driven economy. So, for instance, whether it was wheat or whether it was timber, if you wanted to ship your goods to market and wanted to make a profit, then you're going to have to use the railroads. This gave the railroads an unfortunate amount of monopolistic power over the shipping of these resource goods. And because the monopolistic power was there, it began to be abused. So, for instance, there's the Northern Pacific Railroad. There is an example of them using this power to essentially drive a particular lumber company essentially into something approaching bankruptcy by just raising their rates to such a high level they could no longer economically move their timber. And they were doing this in a discriminatory fashion. They were charging different rates to different companies. They chose to raise the rates for this particular company to such a high rate that it became unfeasible for this company to continue to operate. And so what happened is this company chose to sell its timber interests to a different company, to its competitor, in order to get out because it could no longer run its company without making a profit. It just so turned out that its competitor was principally owned by the same owners who owned the railroad. And so this was, of course, a very convenient way to use the monopolistic power of the railroad in order to enrich the investors in the railroad by essentially using the discriminatory monopolistic power to force one timber company to sell to another. So this was the kind of example that led to the Congress deciding that this kind of monopolistic power is not in the best interest of the United States. And so in theory, this kind of monopoly could have been put into the courts, and the courts could have handled these kind of disputes, whether under some kind of monopoly law, or they could have set up some kind of standards where reasonable rates might have been a standard that would have been proposed and would have been made available so that a shipper had to essentially charge only reasonable rates for shipping resources. And so rather than giving to the federal courts directly, instead the Congress set up the Interstate Commission, which essentially acted as if it was a court. They appointed essentially administrative law judges who happened to be experts in economic experts in this kind of resource allocation and in industry and transportation. And these were the essentially the judges for this kind of situation, and the reasonable rates were set by the ICC. So essentially this was seen as a quasi-adjudicative responsibility, and it was essentially run that way for over 100 years. And this was an independent agency. It was not under the executive branch. It was a 7-person commission. It was the president appointed the commissioners, but the president did not have the authority to remove the commissioners. It was a depoliticized commission. The appointments were staggered over several years, so no one president could appoint all the commissioners. And the commissioners could not be fired unless they had done something wrong, unless there was some kind of cause, some kind of illegal or unethical behavior. And so these were independent commissions because they were seen as engaging essentially a quasi-judicial function. So this was a good example of the very early idea of an independent agency.
Yeah. And so if I'm tracking, it sounds like the ICC, this Interstate Commerce Commission, was created in the 1880s. And what was happening is that there was a railroad company who raised rates for a lumber company kind of put that lumber company out of business. They had to sell to a competitor lumber company, which that Northern Pacific Railway also owned. So it turned into kind of a little bit of a self-dealing here through pressure. And so the government set up this commission to keep that type of behavior, the monopolistic behavior, from happening. And I mean, could Congress have just passed a law saying that, they can't do that instead of creating this agency?
That's exactly right. And then it could have been just done through the courts. And so the situation that arose here was that the Congress felt that it did not have to be just limited to the idea of strictly putting this into the federal courts, but that they had the option of putting into what they considered to be a professional agency that was something that looked like the courts, that didn't have, interestingly enough, the exact parameters of a court. Remember now, federal courts, if you know anything about the judiciary, the federal judiciary, judges do have lifetime tenure. These agencies would not exactly look like. So these were quasi-adjudicative agencies. But this was something that was started in the 1880s and has now morphed into, as we said, at least 100 different kinds of agencies that will have this kind of mixed authority and mixed ability to act in a way that is not classically an executive branch agency, but has this kind of mixed quasi-judicial function. And then we also have the example of agencies that act more by regulations, where the agency, rather than doing adjudicatory functions, will have a law and they will issue different regulations that are then going to give examples or going to give further parameters to a particular law and issue regulations. And those are seen as quasi-legislative, and some of those are also independent agencies. So for instance, the Federal Energy Regulatory Commission might issue regulations on how energy is going to be regulated. Security and Exchange Commission might issue regulations on how securities are going to be litigated. So again, there's a very robust economic regulatory system that has long operated in what appears to be not so much the executive branch, but essentially in these quasi-legislative and quasi-judicial functions that are not strictly directly under the president, because, again, the president can't directly eliminate the commission or can't take away the people who have these positions of authority.
That's helpful. And I'm going to, I think, ask one more question about kind of the setup of these independent agencies before we kind of pull it back to current events. But you described kind of the 7 commissioners who were appointed to staggered terms, and they were kind of bipartisan, or partisan, but they were appointed by both political parties. And so, is that how all of them look? Is there any kind of regulation on how these are set up and what they need to look like?
So that's a great question. This is why I did not like administrative law. Administrative law is notorious for every time Congress decides to set up a different agency, it will often make just a slightly different adjustment to how it is done. So the ICC stands as a pretty good example of how a lot of independent agencies have looked, but you have seen almost every possible variation of number of commissioners, how long their terms are. In some cases, there have been independent agencies that have single agency officials put in charge. That actually came up in front of the Supreme Court recently, and at least in a few cases, this was a Celia Law Supreme Court case that came up recently, at least for the Consumer Finance Protection Board. That was actually found to be too close to an executive branch agency, and so that was struck down. It was also struck down because they're seen as engaging in too much executive function. But there have been really a whole number of different variations in how these independent agency look, and to increase the confusion even more, there are agencies within agencies, and there can even be independent agencies under executive agencies, meaning you might have an executive agency, but then you could have an independent agency who, although to some extent under the structure of that agency, could still have an official who is not removable by the president for unless there is cause. And so the complexity of administrative law is really as complex as Congress might imagine at any one time, because each time Congress passes a law involving a creation of a new agencies, they really have pretty much carte blanche to create it as they see fit, even though there is a certain amount of similarity between many of them.
So I guess, what you're describing feels pretty flexible, even though, the kind of the makeup of like the seven commissioners as one model, as one of the models with staggered terms, that feels, pretty protective. But beyond that, it feels like pretty permissive and a little flexible in how it's kind of brought about, and then kind of what they oversee and what happens with them. So why are we seeing that this administration is trying to kind of get rid of the concept of independent agencies?
Well, that's a great question. So I think we can step back a little bit and recognize that separation of powers, which is really what we're talking about, the idea of where does power go in between different agencies, has always had a bit of a functional formalist distinction, meaning that in some cases the court gets very closely hewn to the text of the Constitution, and in other cases they can be a little more flexible as to how they interpret what is actually the meaning of particular terms and how strictly they're going to adhere to how it is done. So you'll see the Supreme Court go back and forth on how strictly it adheres to particular terms. Now, in this particular case, what we are to some extent talking about is whether or not the term executive power, which is used in Article 2 in language that says essentially the executive power shall be vested in a president, meaning there will be one president, what that means. So when you just say those two words, executive power, does that have some kind of Talmudic wording that then encompasses some very, very specific meaning? And then we are now off into the wonderful world of constitutional interpretation. For those of you who've been following our podcast, we are now back to that very complex area, is how do you interpret the Constitution? And in this particular area, we are now back to the issue of originalism and whether or not originalism should be used in this context, whether or not this is one of those issues where we should only be paying attention to what was done in the beginning, and whether or not, if something was done at the beginning, whether or not can only be done in that particular way, or whether the Constitution should be allowed to have a little bit of flexibility into it. So that's kind of the theory of originalism. And this has been pretty much encapsulated since the 1980s in something called the unitary executive theory. Now, the unitary executive theory is something we covered in a different podcast a little bit earlier, because the unitary executive theory and this idea that the executive power, just those two words, means a whole lot more than we have thought it meant in the past. We talked about that in the context of President Trump firing federal employees, saying that he could eliminate the Department of Education, using some very expanded arguments that he could control pretty much any aspect of the executive branch. And so the unitary executive theory, in that much broader sense, is actually a relatively new invention, really something that has not been practiced in any real sense except by President Donald Trump. However, in this much narrower context, which is the idea that independent agencies should not be able to exist independently, that's really where the unitary executive theory came from. And the principal argument of the unitary executive theory is that this idea of the president not being able to fire an agency official, that's something that in theory has been unconstitutional from the beginning. And now, why do we think that this is this is something that the Supreme Court might buy off on? Well, we didn't until relatively recently. So the precedent saying that an independent agency can exist, that an official can be protected from being fired, goes back 90 years. It's the Humphreys executor case, which essentially was a unanimous decision where the FDR, Franklin Delano Roosevelt, president, tried to fire a Federal Trade Commission commissioner, and the commissioner refused to be fired. And the Supreme Court held, no, we accept the idea that there can be these quasi-judicial, quasi-legislative agencies that operate to some extent outside of the president's purview. And that has been good case law for 90 years. And that's why we have over 100 independent agencies. So only recently in the Celia Law case, which comes from about 2020, do we have language from the Supreme Court where you get the sense that they do like the executive power argument a little bit more than was perhaps apparent from before. And so the possibility exists now that the Supreme Court is in fact behind the unitary executive theory, and that going forward, they might be willing to jettison what is essentially 90 years of the growth of the administrative state, which would essentially completely upend the independent agencies and their independence from the president, and put what has up to this point been a number of essentially independent agencies who have been able to work kind of in much more of a long-term, in the interest of the United States, absent political expediency, and put them all under whatever the particular administration who is in power at the time wants at that particular moment. So it's a very, 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 very big deal.
Yeah, and so one thing that's confusing to me about kind of being able to undo this is that, you said that Congress was the one that kind of created the first independent agency, and I'm presuming that that's been the case for the most part as well. And so how is it possible first, I guess, is that true? And then second is, how is it possible to like then undo that?
Well, essentially, it's being undone by deed. President Trump came in and he immediately
Mhm.
fired two federal trade commissioners, Democrats. He then fired a couple of equal employment opportunity commissioners, fired the Office of Special Counsel, fired the National Labor Relations Authority, a commissioner from there. He has essentially, he's going to pretty much bring this to the Supreme Court by firing everybody that he feels he wants to, and then making them sue to either retain or get back their job. And so that's how this is going to get to the Supreme Court, is fairly directly and possibly quickly, although the law can move relatively slowly in these cases. They might actually, Supreme Court might let this move its way up through the courts. They may not act quickly to resolve these issues, and so we might actually take a little bit of time before we see how this resolves. But that's essentially, it's going to be done on the ground, and it's going to be done with essentially just resolving what has already happened to some extent. A number of these people have been taken out of their positions and are no longer acting in their positions.
Okay. And so I guess the bottom line, though, is like, why do we care? Why are these independent agencies important? You talked a little bit about that regulatory function and the quasi judicial function, the quasi legislative function, but kind of what's the bottom line on why we care right now? Why are they important?
Well, I will say that before any of this came up, in the sense of before President Trump started firing people, I would say to people, well, I don't think he's going to do it. And I have two words to say why I don't think he was going to do it. And those two words are the Federal Reserve. Three words. So the Federal Reserve is, of course, the body that controls the monetary policy of the United States. And it's actually a fairly complex setup. There is the Board of Governors that are elected by the Federal Reserve banks, and then there are other various boards. But the Board of Governors are essentially it's an independent agency. And so in theory, if it's an independent agency, then that means the Board of Governors, each one of them could be fired. And that means that the chair, Jerome Powell, could be fired by President Trump. Central banks are seen by modern economic theory as incredibly important to the long-term stability of any economy. And it is not only important to modern industrialized economies, but it is actually seen now as important to economies that are not as industrialized, because absent that kind of stability, it's actually very hard sometimes for developing countries to get out from under the economic problems they can get into. And sometimes it's the conditions that they need to meet in order to even get loans from the World Bank, or even to get banks to loan them the money they need to get out of situations. So it is very, very important for a central bank to have independent monetary policy. One example that we've seen recently of a ruler having a non-independent monetary policy is in Turkey, where President Erdogan has a novel economic theory, which is he believes high interest rates causes inflation, which is pretty much the exact opposite of every economist throughout the world. And his implementation of his theory has led to Turkey having some of the highest inflation rates in the world. The idea of bankers being responsible for setting interest rates in order to try to balance economic growth with inflation is just at this point absolute set in stone, the way that you have stable economies that don't have too much inflation in it. And so the idea of having the Federal Reserve independent has generally been presumed to be sufficient to keep independent agencies as a bulwark of that kind of protection. And so, interestingly enough, President Trump issued an executive order saying essentially there is no such thing as an independent agency. I can fire everybody. All independent agencies have to send all the regulations through the Office of Management and Budget. Myself and the Attorney General set all policy for all independent agencies except for the Federal Reserve. And so he exempted them. But of course, constitutionally, by throwing down the gauntlet and trying to set the stage for the Supreme Court to allow him to do that, then he essentially would knock down the barrier to the Federal Reserve being available for that kind of action. And having said that, just I think 24 hours ago, President Trump essentially threatened Jerome Powell and said that I can fire him if I want to. I think he should lower interest rates right now. So essentially, the Federal Reserve is kind of the big prize, but they're all prizes. Federal Trade Commission right now is suing Meta, which owns Facebook. Facebook bought Instagram. Facebook bought WhatsApp. They're in the middle of a huge monopoly suit right now. It's certainly possible that if President Trump believes that he is running the litigation strategy for the Federal Trade Commission and this is a monopoly case, then in theory, he believes he could cut a political deal with Meta and demand something from Meta, and then just cut a deal where the litigation goes away for Meta cutting some kind of political deal. So the independent regulatory power, it's a huge part of our economy that it regulates. Up till now, it's been regulated without direct political interference. Direct political interference would provide the opportunity for a whole level of political interference with our economy that has not existed before.
Yeah. And I know, I haven't read Project 2025 in its entirety, and I know that there is a section about the Federal Reserve, and pretty much as far as I understand it, and encourage folks to do a closer read if this is of interest to them, there is like a desire to abolish the Federal Reserve as kind of one of the objectives. And so kind of your point of concern being like this is the big ticket item is a really important one. And it's also one that is part of some playbook, whether or not this is the playbook they're following. Seems like they are to some extent, but it feels not as far-fetched now than maybe when you were telling folks that you don't think Trump would be doing this.
I was just going to say there really is a difference between trimming the sails on regulatory agencies and setting up a situation where there might be a preclusion of entities getting involved with economic regulation. I mean, these are two completely different worlds. And one option that is being presented here is essentially to have economic regulatory agencies just bow out. And that is a completely different scenario, something we haven't seen in generations. And I'm not an economist, and all I know is that in the past, we certainly had depressions that would have not been replicated in many, many years. And there's probably nobody alive today that remembers those depressions in any serious ways. And that may be part of the collective, unconsciousness of what is potentially at issue here.
Yeah, and I think that's also a good point in terms of like historical context. The Federal Reserve was created in the early 1900s, right, to kind of respond to some of the fiscal policies and the panic that was happening at the time, and so it will be really tested in the way that our economy's grown. What would happen if the Federal Reserve were to be impacted? I liked kind of the examples you showed, though. So, what about other independent agencies?
Well, I think the main thing to remember is that there are just entire huge areas of law and of regulation that are at issue here. So, for instance, labor law, the National Labor Relations Authority, that is a independent agency that engages in essentially adjudicatory function every time there is a union dispute, then it couldn't end up in front of the Federal Labor Relations Authority. And in some of these cases, what's interesting is it's less about the regulation and more about the adjudication. It is a backstop, and it doesn't even have to be something that happens every time. It's just the idea that there is some place that the entities can go, like the labor union can go, or the business that can go, that actually keeps things running smoothly. It's just the idea that there's some regulatory structure that sometimes keeps things actually running. And it's when you take away those structures that we begin to miss them, because essentially then you end up with true labor strife. And the way that we used to have it years ago, labor strikes that went on for long periods of time, labor strife that had to be intervened by the government, labor strife that had to be intervened with by force. I mean, this is something that was in our history. We also have things like Consumer Product Safety Commission, where people don't remember that a lot of toys used to be very poisonous. A lot of cars used to be dangerous. A lot of people used to be harmed by consumer products because there was no particular reason for businesses to put out safe goods. Certainly, many businesses put out safe goods, but all you needed would be one business to put out a large number of items that were not good or not safe, and then that business could actually just kind of disappear once it had made a lot of money and leave a lot of damage behind. And these are the kinds of things that these agencies exist principally because of large effect damage that was done in particular instances, and the results of them were such that they generally led to some kind of regulatory scheme. And you can really just kind of look behind a lot of these agencies, and you just find historical stories, historical reasons, things that we don't even think about having to worry about anymore. But that the reason we don't is that they don't happen that much anymore. The National Transportation Safety Board. Planes are very, very, very safe. Having said that, we have seen probably 4 or 5 accidents in the last 2 months that are shocking to people. We've had helicopter crashes, we've had near misses with congressmen, we've had some things that have been happening, and people are not used to this. It is really pretty uncommon. And the reason it's uncommon is that every time there is a major air crash, there is an investigation, and then there is follow-up, and there's enforcement. And this is why we have a hugely successful airline industry that often dominates other transportation industries, is because people see it as safe. Once it stops being safe, the industry itself will sometimes suffer. And that's another thing people don't realize, is that businesses are often very interested in regulation. Obviously, there are limits, but they want regulation because they want to have consumers who are comfortable with the idea that there is enough safety, that there is enough regulation, that they are going to utilize the services. So there really are a lot of agreements within our economy that people don't recognize, that people have just gotten used to, and that if they go away, people will miss them. And I think that is a big part, again, of the independent agencies. I think the independent agencies are just one of those, they're background noise to most people. They might hear about them occasionally. Doesn't concern them because mostly they have functioned for years and they continue to function. And things that threaten them, I think, will probably not be missed immediately. They might not even be missed within a couple of years, but ultimately over the long run, they certainly will be missed. And then essentially they will probably be replicated in some form at some later date, but at what political and legislative cost, it's hard to say.
Yeah, and human cost to your point about the safety. So I appreciate that perspective, especially, we see this in public health a lot, right? Like when you do it right, then you save lives and no one knows, right? You don't get the credit because it's preventive. It's the thing that keeps that major disaster from happening again, as you're describing. And so I love that frame on it. Okay, so I think we've covered everything that we wanted to cover today. We talked about the different types of agencies, the executive agencies and the independent agencies. We talked through some examples, the first example of an independent agency, as well as more near-term ones, kind of the theory that this administration may be operating under to try to get rid of these independent agencies, as well as why they're important, particularly in the case of the Federal Reserve, but then as well as other agencies. I don't know if there's anything we left out or if you wanted to bring anything else up here before we close, Ken.
No, I think that's it. Again, I just feel like this is an important issue that is probably it's not a common part of our language yet, but it really should be.
I love that. And I think it gives us all the opportunity to understand our government a little bit better and understand the work that has been going through these agencies and the safety they've been providing for folks all these years. So thanks so much, Ken. And thanks everyone for listening, and we'll see you next time.
Thanks, Adna.